Representative Larry Metz.
Good evening, ladies and gentlemen. I really appreciate the opportunity to be here. Can everybody hear me all right now? Okay. I will try to get up on the mic. And wanted to start out by saying that Andy's going to be bringing around a handout that I prepared. We don't have enough for everybody to have one on the room, so if you're here, married couples, for example, just share one if you can, and hopefully we'll have enough to go around if we do that. And I want to start out by just sort of explaining or setting up what we're trying to accomplish here tonight, because I know time is limited, and we're talking about 11 different amendments to the Florida Constitution that are on the ballot. So it's going to take us a little bit of time to go through them, and so I wanted to sort of set it up for you by indicating that my goal is to just try to explain what they do in terms of how they would change what's there now if they're approved. Every one of these is an amendment to the Florida Constitution, and so it requires the voters by 60% or more to vote on those amendments say yes. If the required threshold of 60% is not met, the amendment fails and the change is not made. So that will be true for every one of these. If you're voting, you either vote yes or no when you get your ballot on all of these. That's the choice, or you don't vote at all. That would be another choice. But yes is to approve the change that's in the ballot summary that you'll see. No would be to reject it. Now, every one of these amendments was proposed by the Florida legislature. That is one method for getting something on the ballot for the voters, is the legislature, by a supermajority vote, approves it, and then it goes to the voters. There's other ways petition drives can occur, and there's also a commission that meets every 20 years that can put ballot initiatives on there. But all of these were by the legislature. And it was either during the 2011 or 2012 legislative sessions. We could probably get those handouts going. I just want to make sure you knew that I didn't have enough. I didn't know the turnout was going to be this great. I'm glad to see everybody here, but I didn't bring enough copies with me. Now, the 2011 and 2012 sessions were both, I wanted to set up the fact that the legislature in those two sessions, 2011 and 2012, had in the House, out of 120 members, there were 81 Republicans. And then in the Senate, there were 28 Republicans. So if you just think about the mathematics of that, if a supermajority vote was required to get these on the ballot, then you would have had certainly a majority of the Republicans voting for them to get them on the ballot. And I think they were supported by the Republican caucuses in both chambers, and as well as from Democrats. With that in mind, what I'm trying to do is just explain them to you so you can understand. We don't have time to really get into an open dialogue. I'd love to have town hall meetings where people can share ideas, but time doesn't permit that tonight. The goal is not to convince you to vote one way or the other. I'm not here to do that. Everybody here has an equal vote on November 6th on these amendments. I, as a legislator, could vote on them. That was only whether to get them to the voters for a petition. But then I get to vote as a voter, just like everybody else. So on November 6th, yes or no on every one of them, as do you. So if you find yourself disagreeing with anything you hear about here today or later, you always have the right to vote no. Or if you like what you hear, you vote. You could vote yes. And if you are not sure, then there's a way to get more information. Now, the handout that's coming around on page 1 talks about how to get more information. So I'm a big believer in having as much information as you can have before you make an important decision. And that's why I wait till I'm fully informed before I decide how to vote for something. Unless it's a no-brainer, which there are some of those here. Now, the first, there's under the heading for more information, there's two links that I provided. One is to the Division of Elections website. So if you have your computers at home and you follow that link that I have, the first one on page 1 of the handout, right there, that first link, you can go and you can see the entire text of the actual amendment, as opposed to the ballot summary, which I've repeated verbatim under each of the headings here. The ballot summary is required by law to be provided by the legislature when they vote on it. And you might look at it and say it sounds legalistic in some cases. Well, that's because there's legal requirements that the Supreme Court will scrutinize us over to make sure that it's complete and not misleading and so forth. So sometimes it does have a little bit of legal language that is hard to decipher, but that's in order to make it sustained by get it through the court review. So if you want to see the actual amendment where they have the language of the Constitution that's in question, and what's there now lined out, and what's going to be added underlined, you can see it in context. You go to that first website. Now, if you really want to get more information beyond the actual full text of the amendment, you can get what we had when we were voting on these in the legislature, which is the staff analysis report. And this is professional staff people in the Florida House or the Florida Senate, wherever the bill originated. They write up a full report on what the current situation is, what the changes would do if they were effective, and what the fiscal impact would be. It's a very well-written summary in each case. That's the second link on page 1. But I've got to give you a little bit of further explanation. I tried to do it below that in the writing there, but in order to really know how to search that website to get the information, you're going to need to know, and this is provided here, starting with number 1, say on page 2. You'll see I have there the bill number, and it will say Senate 2011. That's on page 2 of the handout, and there's one of those designations for every one of the amendments there. So when you click on the second link on your website, it takes you to the House Bills category. It will say Bills, and it will be defaulted to the 2012 session for House Bills. But you can click on there and change it to 2011 session. You can also click on there to change it to the Senate instead of the House. So, for example, if you were going to go get the staff report for amendment number 1, you would basically need this bill number, and you would know from the parenthetical there it says Senate 2011. So when you click on the link, you got to change it from House Bill 2012 to Senate in 2011, and then click on there, and then add the bill number, and then click again, and you'll see the bill thing come up, and then click on that, and it will give you the whole history right there. And the staff analysis is one of the categories. You just go to the one that says Final Bill Analysis, and click on that. It's a PDF, and it will give you a full report. I have them all here, but it's basically just a very detailed report, and then you just pull it out and just show you the bill analysis and fiscal impact statement. Starts out with a summary, a short version summary, if you will, and goes into all the different details of it in a very legal and very easy to follow format. I mean, very good information. So that's there if you want it. I just wanted you to know there's times before November 6th to educate yourself more about these than what we're doing tonight. I'm going to try to give the bigger picture and then some of the rationales behind it or why it was something that was proposed to be changed. And then hopefully you'll have enough information to do your further consideration of it and make a decision. So any questions on how to get more information or what we're trying to accomplish here or anything of that nature before we go into the First Amendment here, the very first one we're going to cover? Anything? Okay, good. We're making good progress here. All right, number 1 is going to be, if it's approved, would add new rights to the Florida Constitution that deal with health care. Now, some people have referred to this amendment as sort of exempting us from the Obamacare health care reform bill. I want to, if you've heard that before, it doesn't exempt us specifically because that bill, since this was passed, has been upheld by the U.S. Supreme Court. So there's a lot of things that could happen with the Affordable Health Care Act. If we have a different outcome of the election, if we have a new president, for example, and a new Senate, it could be repealed. But if it's not repealed, then I don't think that Amendment 1, adding these rights that it does, would necessarily exempt us from it. It would set up perhaps a legal battle on that issue if it ever got litigated under the 10th Amendment, which would be an argument that, well, the police power for this area belongs to the states, and we have rights in the state of Florida, we put them in our Constitution, and there could be a litigation over that type of issue. But I don't think that's really the thing that we can expect to get from this unless somebody challenges it and it goes in the court system. What this does, it creates these new rights that I mentioned, Section 28 of Article 1 of the state Constitution, to preserve the freedom of Florida residents to provide for their own health care. And it does three things. It ensures that any person, employer, or health care provider is not compelled to participate in any health care system. Now remember, the Federal Affordable Health Care Act does compel people to participate or pay what they ended up calling a tax or a penalty. So this would say that any person in Florida or an employer or a health care provider can't be compelled to participate in any health care system. It also authorizes a person or an employer to pay directly without using a third party, such as an insurer or an employer, for health care services without incurring penalties or fines. In other words, freedom of contract for health care services is preserved here. So you can go to a doctor under this right that would be created if it passed, and then you have the freedom to choose a doctor and then go there and get the services from that doctor and pay yourself just like you would anybody else who paid for a service. That would be a right that would be enshrined in the Florida Constitution. The third thing, it authorizes the healthcare provider to accept direct payment for healthcare services without incurring penalties or fines. Again, on both sides of that free market healthcare transaction, patient and doctor, patient and clinic, whatever it might be, this would preserve the right to have that interaction without penalties from governmental entities for failing to participate in another system and doing it on your own. So what would be the practical effect of this? I'll just give you a hypothetical to illustrate it. Let's say that the Affordable Health Care Act, the federal Obamacare legislation, was repealed. So now we don't have a federal system overlaying us anymore under that act. States then would be back where they were before. And we had before, for example, Massachusetts had their own version of a health care reform bill under Governor Romney. We know about that. We've read about it. Well, that was, and Governor Romney's statements about that, one of the questions about it is that, well, that's something at the state level, and that's something people in that state decided to do at that time through their elected officials. And we 10th Amendment believers find that persuasive. I mean, I certainly understand the 10th Amendment preserves the right of the states to have decisions to make like that. So we also have the right to say we don't want to be compelled into a healthcare system, if that's the case. And so this amendment, if it passed, and we didn't have that federal issue looming on the horizon, it would prohibit the state of Florida acting through the legislature coming in the years ahead and superimposing on people a mandatory health care system. It would also prohibit counties and cities from doing that within their jurisdictions. So it would preserve the ability of individuals to provide for that health care through their own decision making. That's it in a nutshell. I mean, it's much more complicated when you read the report. I try to give you the highlights of the time limitations. Now, you know, for the people on the other side, it might, there's different arguments that can be made. Some people say, well, leave well enough alone, don't have these rights in there, we don't need them or whatever. I'm not here to try to open up all the different arguments for and against. I'm trying just to explain what it would do based on the plain language of the amendment. And then you have to give it consideration and all. But I do believe that these rights, certainly in Florida, from Florida state level going down, certainly are within the realm of the state of Florida to do. I mean, we can say as a people that we want to have these rights. It's a question of whether we should or not. That's for you to decide. Any questions on number one? Okay, we're going really well here. We'll move on to number two. Now, this is more of a technical, it's a substantive change, but this has to do with a homestead property tax discount for veterans who are disabled due to combat injuries. Now, there already is such a property discount in the Florida Constitution, but it requires that the veteran to qualify has to be combat-related injury, and the disability is determined by the Veterans Administration. But they had to be in Florida when they reported for military duty. When they left to go in the military, they were coming from Florida in order to qualify. This would change that, and it would say that they don't have to have the Florida connection at the front end of their service. But if they did go in the service, and they did go in combat, and they were injured in combat in the line of duty, and suffered a disability as a result of that, and then they end up living in Florida, this would authorize that additional tax exemption from property taxes. So it's fairly narrow in its application because you have to qualify. You have to be a veteran who was disabled during combat, as determined by the Department of Veterans Affairs, and then it would be a percentage of tax savings equivalent to your percentage of disability that you would get. So try to give you an idea of the fiscal impact. It says the number of veterans who may qualify for the proposed benefit in this bill would be approximately 74,000. And recurring, they had for the total impact financially over the whole state for fiscal year 13-14 would be about $2.4 million statewide. And then it would go up to 4.9 million in 14-15, 7.6 million in 15-16, and then after that, about that same amount. So about $7.6 million in less revenue being collected from property taxes because of the veterans who would be anticipated to be qualified under that. Yes, sir.
Larry, I'm sorry, two quick questions. for you. The first question is, are there any provisions to make up for the shortfall of revenue that would represent, or would it be up to the other residents to make up that difference?
Well, it would be the latter in terms of there's no offsetting financial mechanism in the amendment that says, okay, here's where you get that $7.6 million from recurring. It would be up to the local governments that do not collect that money to either decide to spend less or to raise taxes to cover it elsewhere. So that would be a local decision.
So everyone else would be getting an increase?
Well, not necessarily, because there's not an automatic mandate that they increase their taxes. They can always keep them the same or lower them, but they have to find a way to balance their budget. So they're going to either stop spending that, I mean, collectively, you know, if you assume the $7.6 million number is correct statewide, then there'd have to be $7.6 million in either new revenue to make up for it if you wanted to equalize it, or $7.6 million in cuts in current spending to cover it.
Have you decided yet how you're going to vote on these issues, or, and if so, would you share that with us?
Well, I'd rather not try to lead you down that path. I voted for all these to put them on the ballot because I thought they were all meritorious enough for the people to consider. And personally, I mean, I can give you my personal opinion if you ask for it. I don't mind doing that. I'm going to vote for this. But that doesn't mean you should. It's just, then I really get back to the thing that if I'm in Tallahassee and I'm your representative and you're calling me saying there's a bill coming up, I want you to vote for it or against it, and I hear that from different people and I take that all into consideration, I'm in a representative role. I need to be listening to my district so I can be told how to vote. And that's a proper, you know, exercise of communication by the constituents to the representative. When we get to this situation, I get to vote on November 6th just like you do. So my vote belongs to me and yours belongs to you. And I'm trying to share the information because I think it's my obligation to try to do that, being I was in the legislature when these were passed. But I don't think I should be telling you how to vote because you're capable of reaching that decision on your own. And when we add it all up, we'll either have 50% or not. I felt strongly enough to put them all on the ballot for you because these are things that we can make our decisions on.
Larry, I missed the distinction. What's the change? The veterans that are disabled while they're in Florida?
No, it has to do with where were you when you entered the service. Right now, to get the tax break, if you voted no and this stayed the same, for example, the veterans that are eligible for that tax break not only have to have the combat-related injury as determined by the U.S. Department of Veterans Affairs, but they had to report for military duty out of Florida. They had to be in Florida when they left before they got injured.
So a Florida resident at the beginning of their life.
Yeah, in other words, they were in Florida, they went in the military, and then they came back and they were injured and they get the benefits.
So if you vote for this, then what's the change?
The change is that we no longer would have to have the nexus to Florida at the front end of their military service. A veteran who lived his entire life in Michigan, let's say, could move to Florida and bring with him, of course, his physical condition, which is his disability, and then be able to qualify for the tax benefit of his impact.
So it would be for any disabled vet rather than for any?
Well, disabled veterans due to combat-related injuries, because some of them are disabled and they're not from combat. It's pretty narrow. 74,000 out of a state of 20 million, or 18 million, maybe 20, a little bit more. Yes, ma'am.
What is the discount?
Well, it's a percentage of the homestead, of the valuation based on their disability rating. Let me try to find something more specific here on that.
Is it significant? Does it amount to quite a bit?
Well, the fiscal impact statewide, as I mentioned, was at the end of the third year was going to be 7.6 million, or yeah, recurring would be 7.6 million. No, well, it means per year, yes. The recurring means per year. Let me just find the actual. Again, we already give this discount. It's just a question of extending the eligibility to those who were not in Florida. Let me try to find this here. Each veteran who is age 65 or older and who is partially or totally permanently disabled shall receive a discount from the amount of the ad valorem tax otherwise owed on homestead property if it's combat related. The discount shall be in a percentage equal to the percentage of the veteran's permanent service-connected disability as determined by the United States Department of Veterans Affairs. So So again, let's say they have a 10% disability rating from the Veterans Affairs, and then they would get a 10% discount on their property taxes. If they're 100%.
65 years or older?
It does say that here. That's in the current language.
Is that going to be changed to all?
No,
of
that's
them?
not changed. The only thing that's changed, they're striking out the language about residency at the time of entry. That's all it is.
Well, the young ones need help.
That's not on the ballot.
It's just a matter of whether you think the nexus to Florida is important to keep that and not have the others who came later benefit or not. That's the issue, the policy issue. Yes, ma'am.
Wouldn't that draw more people to the state of Florida, and that would be, they would be collecting more, and then our taxes are going to go up to cover it?
Right.
Well, that gets back to this gentleman's question here about the effect of a revenue change. And that's true with any, we have several of these, and we might as well just cover this generally now, and then we won't come back to it again, because it's going to be the same principle in each case. We have others later on that we'll get to that deal with property taxes as well. And so if you're saying you're going to give somebody a discount, or you're going to cut some assessment cap, let's say, or something, where it's going to result in less revenue being collected by the local authorities to collect property tax. And property tax is collected at the local level. The state doesn't collect it at the state level, but we do have provisions in state law to deal with it. So, as we gave the example before about the $7.6 million estimated recurring loss of revenue statewide from this change, that can be dealt with by the local government authorities in a number of ways. They can either decide to cover it, whatever portion of that 7.6 belongs to them in their jurisdiction. They can cover that by raising the millage rate on the rest of the certified value. So it would up the taxes of those who are not paying it to cover those who are getting a discount, or those who are paying taxes to those who are not paying it from a discount. Or they could say, we're not going to raise taxes, like the county commission did last week, and said, or I guess it was earlier this week, on Tuesday, right? When Vance was referring to that. But they can decide to cut the budget elsewhere to make up for that. So either cut, I mean, it's unlike the federal government. In the real world of budget, at the household level, at the company level, at the business level, at the governmental level locally, state and local, if you have a change in your picture and you have less money coming in, you're either going to have to get more money to cover the shortfall somehow, or you're going to cut spending. So that's obviously a ripple effect, and we don't know how the localities are going to handle that. That's an issue that they'll have to decide at a local level on all of the ones now. Okay, we don't have any other questions on that one. Let's go to number 3. I have to give a little bit of background on number 3, because what this one is, if you were to go to that website I told you about and look at the full text of the amendment, you're going to see a lot of strike-through language. Looks like this, where they just cross it out, and then there's going to be a whole lot of underlined language where they're adding it new back in. A whole lot of pages of this. When it's underlined, it's being added. When it's being stricken, it's being taken out. So to really give you the full picture, I've got to tell you what's there now. And what it is since the mid-1990s, Florida has had a state revenue limitation provision in the Florida Constitution. It was proposed by a Democrat-dominated Florida legislature under a Democrat governor. The voters approved it, and it became part of our Constitution. And what it does, it has a limitation in there on state revenue that is tied to the personal incomes of Floridians. And what I mean by that is a revenue limitation is described in the Constitution, and it's basically intended to put a cap on what the revenue is collected by the state of Florida at the state level. Not local revenue now, we're talking about state revenue. And so a cap would be in effect if the tax system that we have, which is sales tax and other types of taxes, generates revenue in excess of the cap, there are certain consequences that occur. You can't just keep the money and spend it forever. You have to do something with it. So the current cap increases under current language in the Florida Constitution based on the personal income of Floridians. So as Floridians work harder and earn more money in their personal lives through either their businesses or their jobs, that data is collected, and then they set the limit based on that on a yearly basis. So as a practical matter, through good times and bad, that current limitation has never stopped revenue from being collected, because as we earn more, the limit goes up. So revenue's never stopped by the cap. It's always, the cap's always ahead of where we are on revenue. So if you look at the chart on that staff report, if you go to the website that I mentioned and get the staff report, there's information about that that shows how the limitation has never been effective to stop government from collecting more revenue at the state level. That's the reason for the change being proposed, is to change the language and have it instead read that it would be tied to, the cap would be limited based on increases in population and inflation. Now, if you think about the differences between those two models, personal income means we're earning more money and therefore the cap goes up. I mean, if we do earn more money and the cap goes up, the government can collect more revenue and not be stopped by the limitation. That is basically, I think, geared toward the idea that we have the ability to pay if we're making more money. That's kind of the inherent policy rationale of tying it to increases in personal income. On the other side, the proposed change would take that language out and put in new language that says the cap is set and then it can go up based on increases in population and inflation. Those are two drivers of expenses that government would be susceptible to responding to. So, for example, if we have more people living in the state, we're going to need more police officers, more prison cells, more court systems to take care of that. And if inflation is rampant, then we're going to have the expenditures reflect the need, the inflation. So that's the difference. The cap would be set, and then it would be allowed to increase based on increases in population and inflation. Now, if the revenue collected under the new language exceeded the cap in any one year, the excess over the cap limit would be put into the Budget Stabilization Fund, which is already provided for in the Florida Constitution. And then if the amount of the Budget Stabilization Fund was met, in other words, capped out there as well, we're doing really well, taxes are rolling in, the Budget Stabilization Fund is now full. This language that would be on the ballot in November would say that the excess above that then goes to reduce school property taxes. And if that's not needed, then back to the taxpayers directly. So there's language that says what happens if the cap is exceeded by revenue in any given year that puts it back to the people ultimately. That's one of the changes that was made. So I've given you, again, a short version of it. There's lots of language that's changing out. But the basic thing is we're going to have a revenue limitation either if it passes or if it doesn't pass. We have one now, and we'll have one if it passes. This is different, that's all. Different based on, I think, the idea that the cap shouldn't go up just because we have the ability to pay more, but the cap should go up if government has a legitimate need for more revenue based on changes in either the population or the inflation. Any questions? Yes, sir.
What happens if it goes in reverse?
Meaning,
As it stands right now, you're talking about the aggregate income of the state resident rising. But due to the way things are going, with the dropping, and the cap.
The cap is based on. I don't think the cap drops. It can't increase when income's going down. That's for sure. It might go down. Actually, I think you're right. I haven't really studied that before. The current cap. The problem is the lag between what the revenue is and what the cap is. The cap's always moving ahead of the revenue. It's kind of like you're never able to get there and bump up against it. It barely tapped it one time, never stopped it. It didn't even quite hit it, but if you look at the chart, it just keeps going up. The cap keeps going up and revenue is always below it. So it's never effectively, in good times or bad, stops the revenue from coming in. We had a boom cycle that ended, in 2007, the economic boom that we were in. And revenues were rolling in. The legislature had lots of money to dole out, and they spent up to their income, which forced all these cuts that we've been seeing in the last few years. Because it's not a good idea to take 1 or 2 times increases in income and spend it in a recurring basis. So that was, I think, there were some mistakes made there that when the revenue was rolling in. And it wouldn't have happened if there had been an effective cap. It would have stopped the spending, and it would have forced the money into the Budget Stabilization Fund and it didn't work because our incomes were going really higher because of the times we were in at that time. So the idea is to change that, the fundamental basis of that cap, and to protect the taxpayers from government getting more money in good times simply because we can afford to pay more. Okay, I'm sorry if I can't answer it more specifically. I will check on it, and maybe I can get to you after we're done. I have a lot of information here, but I don't want to take the time to drill down into it right now. But I don't think it certainly wouldn't force government to stop collecting the money if it was below the cap, whether it's going up or going down. As long as the cap is above revenue, it's never going to have any effect on the upside or on the downside. That's, I think, the point. Okay, that brings us to amendment number 4. This is probably the most complicated one that's on the ballot because it's 3 things rolled into one. Have you seen those TV commercials where it's talk about bundling? There's all these commercials online. I've seen them every now and then.
We got a septic tank law that was bundled too.
So this was 3 things, and we'll just take them one at a time, but I want to say at the front end that you vote yes or you vote no on all of them, like I said before. But you can't pick and choose the 3 components. You've got to vote for either yes on all or no on all. So the first one deals with the non-homestead assessment limitation. So this is dealing, again, with non-homestead properties. Think of it as business property for the most part. And right now there's a limit on the annual growth in the assessed value. Currently it's 10%. Now for the homestead properties we have under Save Our Homes, it's much lower than that, 3%. So for businesses right now, in good times, if their property values are going up, their non-homestead properties are going up, they can get as much as a 10% increase in any given year. Part 1 of this amendment would change that to 5%. So that's the first part of it. Second thing is a little more complicated, dealing with the Save Our Home issue. And you probably have noticed if you have a Save Our, how many of you have a Save Our Home savings on your trim notice where you benefited from prior years of being in the house over time? You know what I'm referring to? Yeah, you get like a certain amount of money that you accumulated in that, not money, but value is sort of shown there as being, your property went up more than the allowable increase under Save Our Homes, and that difference is kind of added up over years and it sits there on your trim notice. Well, the state of Florida has actually administratively passed a recapture rule that when the property values start to go back down again, like they have been in the last 2 years, some of that accumulated Save Our Homes savings, if you will, can be used so that you will end up not getting a reduction like you thought you were going to get because you're recapturing some of that on the assessment. This would basically allow the legislature to eliminate the recapture of that Save Our Homes savings. So it's, I think, something that property owners who have a homestead exemption would benefit from if, in fact, it was to happen. It says right there that the current language of the recapture rule says where the current year just value of an individual property exceeds the prior year assessed value, the property appraiser is required to increase the prior year's assessed value. Currently, this requirement applies even if the just value of the homestead property has decreased from the prior year. Therefore, homestead owners supposed to Save Our Homes cap this property is assessed at less than the just value may see an increase in the assessed value on their home even where the just value is gone down. So, because they're taking some of that prior savings and moving it over to cover it in the current year where your property is going down. So this would eliminate the ability of government to do that. That's the second thing. The third thing is an additional homestead exemption for first-time homesteaders. And this would allow for an additional homestead exemption for people who have not had a homestead in the prior 3 years. So new homestead claimers, people that buy a house that have not had a homestead in the prior 3 calendar years, would be eligible under this language to apply for an additional exemption equal to 50% of the just value of the homestead property, capped at the median just value for the county where the property is located. So that way you get away from someone getting a real expensive homestead and being out of line with the median just value in that county. So say, for example, the median just value in a county like Lake, I don't know what it is, but let's say it was 100,000 for easy numbers, then they couldn't get more than 50% of that for their exemption. It should be a $50,000 homestead exemption that would only be in effect for 5 years, and it would decline every year 20%. So it would be phased out over a 5-year period. I think this has its genesis in Florida's collapsed real estate market, and the notion that getting people back into the market through an incentive program like that would be good for the economy. That's probably the rationale for putting it in there. It's bundled with the other two that I mentioned. So those three things comprise Amendment 4. Now, this is dealing not with state revenue, but with local revenue. And the same issue that was brought up earlier with regard to the combat injured veterans that would be eligible to come to Florida after their combat injury and claim the new discount if that was passed by other amendment. How do you make up for that? Well, the same principle would apply here. The local government has to deal with that declaration, that decline in revenue. So they're going to have to decide locally if this was to pass and we had less revenue coming into the cities or the counties because these first-time home buyers have the new homestead exemption, or the recapture rule is no longer hurting homeowners, or businesses are going from 10% to 5% of their annual cap. If all that happens as a result of Amendment 4, then the other side of the coin is then the revenue that's not coming in, what happens? You have to really talk to your local government officials about that. I know Mayor Hooper gave me some information to help me better inform myself about the city's position, and this is not her position, by the way. I'm just mentioning her sharing information. She wasn't advocating anything, but she just said, I want you to have the benefit of this information I just got myself. And so it's by the Florida League of Cities, and they're basically against it, I think. The league is saying that Amendment 4 would hurt new jobs and growing businesses, make their complicated property tax system even worse, etc. So there are other sides to this story that you might want to find out about. But if you go to the Florida League of Cities website, I'm not suggesting that I agree with them. I'm just saying I'm trying to give you the benefit. There are other people out there, or other organizations that are taking a position on it, for or against, and there's a lot of information that can be had if you go on the web and Google it. Probably Amendment 4 Florida 2012 would be probably a good search engine, and just see what you get. So any questions on what these three things would do, or anything of that nature? Yes, sir.
What is your estimated fiscal impact of the
Okay, let's see. We got three different things. So what I've got here in this staff report is that the Revenue Estimating Conference said that the non-homestead assessment limit would have a negative impact on non-school tax bases. Assuming current millage rates, the negative revenue impact on non-school property taxes is estimated to be $118.1 million in fiscal year 2013-14, growing to $406.5 million by fiscal year 2015-16. So that's for the non-homestead assessment limit, the first component. The second one, let's see, well actually the second one would be the recapture rule, and assuming current millage rates, the negative impact on non-school property taxes is estimated to be $10.3 million in fiscal year 2013-14 and $32.5 million recurring. The negative impact on school property taxes is estimated to be $6.2 million in 2013 and $17.7 million recurring. That's the recapture one. And the final one, the new homestead, first-time homesteader provision, it says that the negative impact on non-school property taxes is estimated to be $36.1 million in 2013-14, and a recurring negative impact of $159.3 million. So those are the raw numbers. I read it verbatim for you. This is the kind of stuff you can get from those reports that I mentioned to you on the first page, which is why I thought that would be good for you to know how to get there. Van?
Quickly, is that last item, option 3, for first-time buyers that apply both to used homes and new homes?
Yes.
Okay.
I don't think there's any distinction in that. Just that the qualification is more on the buyer as far as no prior homestead in 3 calendar years. And it is limited to the 5 years with the 20% reduction each year from 100 to 80, to 40 to 0. Okay, now just to give you an idea, I had another piece of information here. that limit on that new homestead exemption is the median price of a homestead in that, the median value of a homestead in that county. Well, they have the two bookends for that. In Monroe County, the median homestead number is 301,000 and change. And in Dixie County, it's 40,700 and change. So it's a wide variation. That's why they put that in there, because if you didn't have that in there, then you could be in Monroe County and be getting a huge additional homestead exemption for those 5 years. Whereas, you know, so they're trying to make it more proportional, I think, by having that in there. That's Amendment 4. I think that's one where, you know, the good source information would be staff report and that I mentioned, and then also checking in with some of your local officials, because here at the Tea Party, we see some of our local officials coming and going to these meetings, and you could take their take on it. Okay, moving right along to number 5, and we'll probably pick up the pace here because we had the most complicated ones already occur here. Let me get to the right page here. Yeah, number 5, which is dealing with state court. This requires a little bit of explanation too, but basically there's, you know, the 3 equal branches of government in the state of Florida, the governor, the legislature, and the court system. And right now, the governor gets a list of proposed candidates for the court appointments from the Judicial Nominating Commission. And we're dealing with the Supreme Court at this point, and this particular amendment. But the rulemaking, I want to first talk about the rule. There's actually a couple of different things, or 3 different things in this Amendment 5. But the rulemaking is the one I've got to explain more. Right now, the Supreme Court of Florida has jurisdiction to pass rules of procedure for the courts. That's their exclusive domain, rules of procedure for the courts. The legislature has the domain of substantive law, passing statutes which reflect policy, and also passing a budget for the state of Florida. So what happens now under the current language in the Florida Constitution, if the Supreme Court passes a rule of procedure, the legislature can, by a supermajority vote, repeal that. But it doesn't really explain what happens after that occurs. And what's happened in the past is that there'll be a repeal by the legislature of a rule of procedure, and the court will come back in and pass it again. And it goes right back into effect when they pass it again. And there's no real end to that tension, if you will, between the 2 branches. So what this would do, it would say that the legislature could repeal a rule by a simple majority, no longer 2/3, but rather a simple majority. But the legislature must give reasons in the repeal for the repeal in the actual bill, why they're repealing it, not just repeal it outright, but explain what the problem is. And then, if the court goes back and passes it again, they have to address the concerns of the legislature when they do that. And if they get it repealed after that again, then they can't adopt it again. It's the end of it. So it does provide for an end to that back and forth. More, you know, information from the legislature during a repeal at a lower threshold, and the court can then address that. And if they do, I think everything will be fine, probably. But if the legislature still has a problem with what they do after they have addressed it again, then they can repeal it once again, and it can't be readopted absent legislative approval. That's one component of Amendment 5. The second thing is that justices of the Supreme Court are currently selected by the governor from a short list from the Judicial Nominating Commission. The Supreme Court Nominating Commission is what it's called. And so there's a list of candidates, and the governor picks one, and that's how they get onto the bench at the Supreme Court level. This proposed amendment would allow for the Florida Senate, would require that the Florida Senate confirm appointees to the Supreme Court of Florida. So there's another check and balance there. But since the Florida Senate doesn't meet all year round, only meets once a year for 60 days typically, if the Senate does not reject the nominee within 90 days, the nominee would be deemed confirmed. That way we don't have to worry about, well, the legislature won't be back till next year, or what they're going to do about filling that vacancy. So they could, I suppose, have a special session if it was called and do the confirmation, but they can also decide not to do it. So it just provides for Senate confirmation. And the final thing it would do, there's a commission called the Judicial Qualifications Commission, which investigates judges for corruption. If there's allegations made that have probable cause, they do an investigation. And this joint resolution would allow the House of Representatives, at the Speaker's request, to review all investigative files of the Judicial Qualifications Commission. The reason for that is that the Florida House of Representatives has the jurisdiction to impeach justices, but if they're being investigated and we don't have access to any of that information, there's no way to be able to act on that authority. So by having information made available confidentially while the investigation is going on, it just empowers the Speaker to make a decision if it needs to be made about something like that. Those are the three things that Amendment 5 will do. Any questions on that? This was basically what was known as court reform during the 2011 legislative session. There were other things that were offered and they didn't make it into the final product. Okay, moving on to number 6. This is dealing with the subject of abortion. I got to explain this a little bit too. I think everyone's aware of the Roe versus Wade line of cases. That's federal U.S. Supreme Court, precedent starting in 1973. There's been cases before and after that, but that's the main one that people hear about. The Roe versus Wade and other cases under the U.S. Supreme Court that have interpreted Roe versus Wade establish what the federal law is on the subject of abortion. There's also been at the federal level in Congress an amendment called the Hyde Amendment, which has restricted the use of federal funding for abortion except in certain limited cases, such as rape and incest. So that's federal law. And that law is out there because it's the federal law. And I mention that because we're in that context of the state where the federal, restrictions there under our federal system. But separately from all that, in Florida in 1978, the voters approved one of these amendments, and it had to do with putting a privacy right in the Florida Constitution. It just said there's a right of privacy. In 1989, the Florida Supreme Court, at the state level, had a case in front of it, and they issued an opinion, and they interpreted the language in the Florida Constitution about the right to privacy by saying that it establishes in Florida a right to an abortion, separate and apart from that federal law that I mentioned a moment ago. So, and the court has interpreted that right to be more expansive than the federal precedents that I mentioned also. So what does that mean as a practical matter? Forgetting what this would do to change it. Just right now in Florida, let's say that the Supreme Court of the United States in Washington decided to repeal Roe versus Wade and all those cases that followed. And just said it was wrong, it was a mistake, and we're going to roll this back and say it's a matter of the states to decide this issue. If that happened at the federal level, hypothetically, Florida would still remain just as it is because that 1989 decision of the Florida Supreme Court interpreting the Florida provision on privacy set a wider policy by judicial decision on the subject of abortion. So the Roe versus Wade repealer would have no effect on what we're doing in Florida if nothing changed at all. This amendment, however, if it's approved, would change Florida's state interpretation on abortion from what it is now to bring it more to where it would be in line, no greater than what the federal government says is required. So let's go through the specifics then with that background. The joint resolution proposes an amendment to the Florida Constitution to prohibit the spending of public funds for any abortion or for health benefits coverage that includes coverage of abortion. However, the prohibition on the spending of public funds for any abortion or for health benefits coverage that includes the coverage of abortion does not apply to, under this amendment, if it passes, it would not apply to expenditures required by federal law or a case in which a woman suffers from a physical disorder, a physical injury, or physical illness, including a life-endangering physical condition caused by or arising from the pregnancy itself, which would, as certified by a physician, place the woman in danger of death unless an abortion is performed. That's the life of the mother. You hear it said that way. That's the language for that. And then it also has there an exception for an abortion due to rape and an exception for an abortion due to incest. Additionally, it says that the Florida Constitution may not be interpreted to create broader rights to an abortion than those contained in the U.S. Constitution. So it sort of forces the state of Florida, which is by a judicial decision in 1989, expanded the rights under state law and pulls it back and says no greater than what's allowed in the U.S. Constitution. So it deals with that whole subject, but it could be confusing to people because when they start talking about, well, it's acceptable under this provision to fund it for these certain exceptions or whatever, people start thinking, well, this may be expanding a new right to abortion that's not there now, and really it's not doing that as I read it, because it's basically saying it brings it back from where it is now, so it can't be any greater than what's permitted under federal law. Any questions? Okay.
I have one.
Yes, sir.
What if they expanded the right to abortions to, as they did with contraceptives under federal law? The way I heard you read that provision, if the federal law expanded, then under this constitutional amendment, the Florida law would expand as well.
Well, no, that's not an automatic under Florida law. Florida law is interpreted, in other words, the 1989 decision that we were talking about a moment ago interprets the state constitution and doesn't really, they're independently saying under Florida's constitution there's a right to an abortion under the privacy language, and it's actually interpreted in the decision or described greater than what the federal government provides in their federal decision. So it doesn't say, this amendment doesn't say we're going to have whatever the federal government says that is okay, we're going to have that automatically. It says Florida Constitution may not be interpreted to create broader rights to an abortion than those contained in the U.S. Constitution. And there's already limits in the amendment elsewhere that say you can't use public funds except in those cases required by federal law.
Ergo, my question is, the federal government expanded, and as they did with contraceptives, to dictate that you will provide contraceptive care under the Affordable
But
Care
that
Act.
wouldn't be because of the amendment, it would be because of the supremacy clause and the fact that we're subservient to federal precedents because of the Supreme Court's decision in Rome. They usurped it. I mean, it was judicial legislation in 1973 that said they could do that. And so, I mean, if they go back and do more of that, we're still going to be victimized by their overreach then in the future as we would be, as we have been in the past. So we probably can't change that with an amendment to our own state constitution. We've got to change out the justices of the Supreme Court if, in fact, they're going to overreach beyond what the Constitution requires. But I think that's what the problem really started from, that they try to create a very detailed framework in Roe versus Wade about that goes beyond the role of the court system. That's just my personal opinion. Okay, anything else? Comment? Very well, we'll move on then to number 7, which was stricken by the court, so it's now number 8. This is the one that's dealing with religious freedom, and it's a very short amendment, but it requires a little bit of history. If you go to the website that I mentioned on the first page, where you can get this full text, the Division of Elections website, this particular amendment, unlike a lot of the others, has a lot of whereas clauses that give the history of what happened before and why this amendment is being offered. But it has to do with over 100 years ago in the country there was religious bigotry directed towards Catholics. And so there was concern when the Catholic schools were being created that there might be a shift of funding to them, and so they tried to prevent that by putting in these amendments to state constitutions, and this happened in many states. And so the language in Florida's constitution, which is a holdover from that era, currently says, and this would be lined out, if you look at the amendment, it's lined out, but currently it reads, no revenue of the state or any political subdivision or agency thereof shall ever be taken from the public treasury directly or indirectly in aid of any church, sect, or religious denomination, or in aid of any sectarian institution. I mean, it's an absolute prohibition on ever using any public money for any type of activity that might be construed to aid a church, a sect, or a religious denomination, or in the aid of any sectarian institution. It's just very, very broad and far-reaching, beyond what the federal government restrictions are under the First Amendment. So again, another situation analogous to the one we just talked about, where state law goes beyond the restrictions that are allowed under federal law. And as a state, we can certainly do that, but is it a good idea? This amendment would take out that language and it would read instead, a new language would read instead, except to the extent required by the First Amendment of the United States Constitution, neither the government nor any agent of the government may deny to any individual or entity the benefits of any program, funding, or other support on the basis of religious identity or belief. So, First Amendment to the U.S. Constitution is the standard, and if that says you can't do it, then this would be in line with that. But beyond that, we're not going to limit people by the language that's there now. Yes, sir.
Larry, wouldn't this open up the tax offers to Islam and other religions?
Well, I don't have a direct answer to that as far as is it conceivable that something like that could happen. I mean, let's take an example of school choice. And you know, we go to a choice system where the parents can choose where their children go to school, and the money would follow the students if the school maintains the required academic standards and accountability. I'm saying hypothetically, that could be a problem under the current language for, say, a school that has a religious affiliation to participate in a program like that, even if they met all the academic standards and the curriculum was consistent with the Sunshine State standards or the new national standards that we're moving toward. So it's very much restrictive now. But in any situation where you have more freedom and more ability for people to make decisions, like the school choice example that I gave you, it's conceivable that somebody else's version of choice will be different than yours, and that's the marketplace of choice that occurs. So I can't tell you that it could never, ever result in, say, some situation like that. I can't conceive of it myself right now, but it's hard to say that something can't ever happen when there's freedom involved.
There's a couple of them in here that look real warm and fuzzy.
Yeah.
They look good, and this is one of them.
Yeah.
And it scares the daylights out of me.
Yeah.
Well, I think you do more reading on it would be a good thing, and then obviously just give it more thought. Yes.
Way in the back.
Okay, way in the back.
Hey Larry, it's
Yeah.
Carol.
Oh, hey Carol.
Hi there. I just wanted to mention to the group, Chris Ann Hall has a good blog on this specific amendment.
Chris Ann Hall?
If you go to her website, she has a blog on this amendment 8 that might help. It's her interpretation of the amendment too, so I just wanted to share that with everyone.
Yeah, Chris Ann, I think it's with a K, right, Carol?
Yeah.
Yeah, Chris Ann Hall has a blog, Carol said, that addresses this, so that would be another source of information for you.
Yes.
Yes, sir.
My opinion, this opens up all kinds of issues in the ACLU about question.
Well, I certainly can see the ACLU liking or enjoying the ability to file suits on things like that, but that doesn't mean we don't do it. That would be, in other words, the reason to not do it is not because the ACLU may file a lawsuit, but you're right, they could. Yes, sir.
For me, I don't know, this has got two things here. Number one, it's saying that we can decide to give funding to certain churches or church schools. Okay? Because the reading the prohibition against. In other words, this will allow money given from taxpayers to certain church schools and churches. That's part one. Number two, I want everyone in this room to listen very carefully to what I say.
Stand up.
Can't
so
hear
we
you.
can
As a citizen of this country, a citizen is allowed to practice whatever religion they wish to or not. Now, I heard someone bring up the word Islam. Okay? That's the new name for it. Used to be Mohammedanism. It's an old religion that's older than any Lutheran sect So any American citizen has a right to worship Islam, Greek Orthodox, Naturism, Catholicism, or not. Years ago, just like you said, law in the city of Leesburg, Florida, prohibited a Catholic church within city limits. Okay? So, there's careful stuff you have to look out for. Because I can visualize down the road with someone saying, it's okay to give money to this church school because 62% of us in this state belong to that faith. But we can't give a dime to this one over here because there's only a few folks here who belong to that faith. And that scares me to death. Thank you.
Thank you. Well, I want to just close this out by drawing your attention back to the language because it's important to read and understand the first part of this as well as the second part. The first part is, except to the extent required by the First Amendment to the United States Constitution. The First Amendment is the amendment that, among other things, talks about freedom of religion. So this is not going to go beyond what the First Amendment would protect. It can't, and it's not going to by its own language to boot. So again, except to the extent required by the First Amendment of the United States Constitution, that's the qualifier that leads you into the rest of it. Neither the government nor any agent of the government may deny to any individual or entity the benefits of any program, funding, or other support on the basis of religious identity or belief. So again, it's just prohibiting religious discrimination in the funding of government-funded programs solely on the basis of religious identity or belief. That's all it does. But it can't go beyond what's allowed under the federal Constitution, specifically the First Amendment. Yes, ma'am.
Does the government fund any of our churches now?
No, direct
they don't.
subsidization of
And,
Federal
but
government.
we don't want them funding our churches or giving money to our churches because then they'll dictate to us what we can worship. Just
And
like
no one's
they've done with the school
advocating
system.
that we're going to subsidize churches with this amendment here. It's trying to remove the vestiges of religious discrimination that occurred over 100 years ago. This Blaine Amendment was in many state constitutions, and it survived the many revisions to Florida's Constitution. So, again, remember, except to the extent required by the First Amendment to the United States Constitution, that has a lot of meaning. First Amendment to the United States Constitution has a lot of meaning, a lot of protection for free speech, freedom of assembly, the petition to redress government for grievances, freedom of religion, and so all that's acknowledged expressly in the language of the amendment. It's just that beyond that, we're not going to restrict you more in Florida than that would allow us to restrict you. So it just opens up the opportunity to have the participation of government in public-private partnerships with, say, a soup kitchen that might be administered by a church that can deliver feeding for the homeless cheaper than the government agency, let's say, as an example. So anyway, that's kind of, I think we probably spent enough time on that, given that it's 8:45 and we have a few more amendments to go through yet. Any more really important questions on that one, or can we move on? Okay, thank you. Number 9 is another property tax issue. Number 9 deals with creating a new exemption for surviving spouses of military veterans or first responders that have died in the line of duty. And this is a complete exemption from taxation for the homestead of a surviving spouse of either a military member killed in the line of duty or a first responder who was killed in the line of duty. And the actual language defines a first responder as a law enforcement officer, a correctional officer, a firefighter, an emergency medical technician, or a paramedic. In the line of duty means arising out of and in the actual performance of duty required by employment as a first responder. The actual performance of duty. And it would be implemented by general law and subject to conditions and limitations means the legislature actually would have to pass implementing legislation that would implement this. It would not be self-executing, it would have to be implemented with conditions and limitations specified by the legislature, or it could be, I should say. And it would be, ad valorem tax would be equal to the total amount or a portion of the ad valorem tax otherwise owed on homestead property to that surviving spouse. So the legislature can fill in the details by general law if this passes. If it doesn't pass, then the exemption would not be created, would not be possible.
Is there financial guidelines on how much we would
Impact.
impact?
We'll see what the impact statement is on it. It's an estimate, of course, because obviously that general law hasn't been passed yet, and the limitations and so forth. I don't think we had much of an impact estimate here, but they said that the estimated impact would be annual reductions in school revenues of $0.3 million, 300,000 in other words, for fiscal year 2013-14, and then recurring. Again, it's a very small universe of eligibility. It would be military veterans or first responders killed in the line of duty. One of them is too many. One of them is way too many. We all know that. But the number of those eligible under this language would be very small compared to the population of Florida. Thankfully, because we don't want any of them to ever suffer that. But in terms of the number of people in Florida versus the number of people that would be eligible, it's a small number, which means the impact is relatively small, 300,000 a year. Yes, sir. I think that's what has to be included in the general law. It's not specified in the amendment. It's a good question.
Thank you. That was my question. If one of the winners from the Twin Towers moved down to $20 million or more and bought a big resort type place, would we be picking up the taxes?
Well, the amendment is silent on that, but it does say by general law and subject to conditions and limitations specified therein. So there you have to have your elected representatives working on a common sense basis to make sure that it was done right, and you have to provide input during the process and hold them accountable, hold us accountable for what we do to implement it if in fact it passes. That's all we can do. Okay, that's number 9. Oh, there's another question? Yes, sir. Yes, sir. I'm sorry, can you say it again?
Cannot hear you.
The wife that is a military personnel as a first responder, the husband would be able to do it.
Yeah, that's the whole, I think it does apply to spouses. That's the surviving spouses of a veteran or a first responder. It does, yes. Okay, anything else, or we'll move on to the next one. We're getting kind of up against our clock here. Okay, we'll move on to number 10. How many small business owners are in the audience? Can you raise your hand? We have a few, okay. Well, you know then, probably because you fill out the forms, to report your tangible personal property to the property appraiser every year. That's required. It's not only the land and the buildings that people either own or rent out, but landowners own either as homesteaders or non-homesteaders. Those people pay property taxes based on value. But businesses also pay property tax based on the value of their tangible personal property, desks, computers, things of that nature. And there's a report required, or a return that's required to be filled out and submitted to the property appraiser's office, and they value that property as well. And you get a bill based on the valuation, unless you have $25,000 worth of property or less in your business, then it would be exempt under the current law. This amendment changes that by increasing the exemption to $50,000 from the $25,000, and does allow for the legislature to authorize counties and cities pursuant to general law to provide additional exemptions from ad valorem taxes on tangible personal property by ordinance. So the thing that would happen for sure if it passed would be the doubling of the exemption from $25,000 to $50,000, and it would authorize the potential for more exemptions by general law, subject to the local governmental entities like the county commission or the cities passing an ordinance locally to give more relief when they're getting rate. So that would be subject to legislative process locally, and people would have an opportunity to have input at that time. So that's really it in a nutshell. Let me try to give you the fiscal impact from this. The Revenue Estimating Conference says that if this is approved by the voters, would have a negative impact on local government revenues of $20.1 million beginning in fiscal year 13-14. But they could not estimate what would happen if the legislature allowed counties and cities to be determined as to what that would be, and they can't quantify it if they don't know what it is. So $20.1 million is the fiscal impact beginning in 2013-14. And it's affecting small businesses because if you have a business, folks that have a business, it doesn't take a lot of stuff to get up to $25,000 right now. When you go out and buy furniture, fixtures, equipment for a business, and you can pretty much get into the taxable scenario pretty quickly. Currently, this would double it to $50,000. So it would have the effect of exempting more small businesses from that property tax to their tangible personal property. And if it doesn't pass, then it would not provide that relief. Yes, ma'am.
When they do these impacts, do they offset, for instance, the impact of maybe bringing more small businesses to our state because the tax is better?
I don't think there's anything in the report that talks about that. I think it would be hard to quantify that. The theory would be, I guess, that if you lower the tax burden on small businesses, you'll get more small business. And that will itself then generate activity and revenue for government. I don't think they can quantify. They certainly did not quantify it in this report that way, but it's certainly a consideration. I don't think it's one that's easily quantified, but it's certainly logical what you suggested. Anybody else on this one? We're getting near the end of it. We're getting close to 9 o'clock, and I'm aware of that. Okay, another tax exemption proposal, and this one is a very narrow universe of eligibility as well. It's addressing senior citizens who are in their homes that we're trying to, the amendment I think is trying to give relief to certain senior citizens that stay in their homes and age in place. And so what would happen if this passed? It would allow the legislature by general law, once again, has to be a statutory enactment following the passage to put the details out there. But the parameters are laid out in this amendment to permit counties and municipalities to grant an additional homestead tax exemption equal to the assessed value of homestead property to certain low-income seniors. First of all, the county or city has to grant the exemption by an ordinance. So that means there's going to be a legislative process locally before it would take effect. Secondly, the property has to have a just market value of less than $250,000. The owner must have had title to the property and lived in the property for at least 25 years. So we're talking about long-term ownership and occupancy. The owner must be 65 years of age or older, and the owner's annual household income must be less than $27,030. So, again, a very narrow universe of people, age 65 and older, $250,000 or less, 25 years of ownership and residency in that house, 65 years of age or older, I think I mentioned, and the annual household income has to be less than $27,030. The general law implementing the constitutional provision must require counties and municipalities choosing to provide the additional homestead exemption to do so by ordinance, and it must provide for periodic adjustment of the income limitation for changes in the cost of living. So the $27,030 income threshold could go up over time to reflect inflation by the ordinance that would be adopted. That's it in a nutshell. Fiscal impact is the only other thing, and the Revenue Estimating Conference says here would result in less revenue to local governments of $9.1 million in fiscal year 2014-15 and $9.4 million in 2015-16, assuming current millage rates. Any questions on that one? The last one is one of the easiest ones. It's more of a housekeeping issue. Currently, there is a student representative to the Board of Governors of the State University System. That's already in the Constitution. And the way that student representative is selected under the current language is that the president of the Florida Student Association is the student member. The Florida Student Association is a private association that has its own legal existence, and the membership is from the student body presidents who comprise it as members, and every one of the universities in Florida joined it, except FSU did not join the Florida Student Association. They didn't want to pay the dues. They didn't think they needed to pay the dues that are hefty, I think, for them. And when they're right in Tallahassee right there anyway. So they didn't really want to participate in that private association, but that made their student body president ineligible to be the student member. So the thought is, well, let's change it so that the association doesn't have standing in the Constitution to be the one that determines who that member is. So the language would just say that it would be, the member would now be the chair of the Council of Student Body Presidents, which council shall be organized by the Board of Governors and consist of all student body presidents of the state university system. So it takes out the entitled status of the Florida Student Association and removes that completely. It just says there's going to be this council that consists of the student body president, and the chair of that council is the member on the Board of Governors representing students. There's no fiscal impact to this. It's just a change in how the person is selected, so that you don't have to pay the dues to the Florida Student Association in order to have your student body president eligible to serve. Any questions on that one? Now, are there any questions on anything we've covered in general about this? I've tried to give you the best information I can give you on it. There's been some really good questions asked and concerns expressed. I didn't intend to come in here and try to answer all the questions. I would if I could, but I can't possibly because there's too many questions. I don't have enough knowledge in one evening like this to know all the answers, but I've tried my best to at least point you to where you can go to get the information. Bill?
I guess this is a general legal question. Why is our Constitution in the state have to have all this instead of Constitution like we have the federal Constitution?
That's a great question, and there's been a lot of folks that have raised that, and the issue has been framed a little bit differently. It was, why don't you all just change this yourselves? That's what we elect you to do. Don't bother us with all this detail as far as the cipher and so forth. But if it's already there, the only way to change it is to go back there and modify it. So the Constitution is already very complicated and deals with a lot of these details, and so we can't, without voter approval, change some of these things. Just like that thing with the Florida Student Association I mentioned last. I mean, it actually named the Florida Student Association, so the chair of that is the one that sits on the board, but we don't need that kind of detail.
It seems like an appropriate step was just to remove that whole statute from the Constitution. I had a similar question, and my experience is that we're in a representative republic. Our U.S. Constitution defines very limited powers to the federal government. All of the other powers go to the states. So the states' constitutions are far larger. Through time, they expand, right? Because that's where the power resides, as opposed to the federal government.
Or that's the way it's supposed to work.
Well, one of the... Thank you, Joe.
In theory.
I'll try to comment on this. Yes, sir.
Is this the wording for the amendment that's going to appear on the ballot?
That's the ballot summary that's in my handout.
This is the actual wording that we're going to see on the ballot?
Yes, we went to that website, we copied and pasted it right in there so that you have that to refer to.
Do you think any normal Joe public should have even understand it?
No.
Well, this is why I put the websites out there for you.
Yeah.
I mean, to get the full text and see the context of it all. Again, I mean, the ballot summary is what's legally required. It's easily copied and put in there for you to take with you. But I understand that you're going to need more information, probably that's why I provided the links and explain how to get there. I think the staff reports, for those of you that really are interested in the details, go to the staff reports and read them, because they will give you a lot of information that you're not going to get from the summary. And it's what we had when we were voting on it, put it on the ballot. Real quickly, we better try to end this soon, because it's after 9 now.
Larry, you've been very patient with us, I appreciate it. I didn't even know.
No, that's okay.
But as a policy, do you feel like expanding entitlements through the use of the tax code is a good idea.
Well, entitlements is a loaded word for me because I think we have way too many of them at every level of government. We have to get away from entitlements and the entitlement mentality we have as a country. That's going to be largely a federal issue, but we don't want to see that mentality expanding anywhere at the federal or state level. Tax policy it's been used for a long time in every level of government to try to influence outcomes in the economy and so forth by saying, well, if you lower taxes, we'll increase economic activity, that will be good for jobs. And so, obviously, taxes have impact on human activity. And the more you tax, the less freedom you have, and the more your money goes to government, so other people decide how to spend it. So, I guess there's policy implications in every one of these tax amendments that we talked about here. In all of them there's policy, but there's tax policy in all of them. For example, you know, if a person is a surviving spouse of a fallen veteran or a fallen first responder, should they have lower property taxes or exemption from property taxes because of that tragedy that occurred to them and the life they have to live after losing their spouse? That's a policy judgment. I mean, that's not so much an entitlement for that person as it is, if we pass it, a reflection of the values we have towards the service and the sacrifice that was made. But if we don't agree with it, we vote no. I mean, it's that simple for all of these. But in other areas where you have like the one that has the three components in one, you have to make a more weighing, you have to do more weighing there and say, well, you know, I like this one, but I don't like that one. Overall, should I vote for it or against it? You have to make that decision. I mean, there's not easy decisions, but we get to make it, and that's one benefit for us. Yes, ma'am?
This is not your handout that we have on our sheet. No.
No, that's not right.
Okay.
Mine is faithful.
What I need to know is, under these proposed amendments and the yeses and noes, whose opinion is this?
I don't know who put that out.
That's from the Conservative Liberty Alliance.
Conservative Liberty Alliance.
That is a group up in the villages.
Village people.
Actually, their origination, they broke off from the Tri-County Tea Party in the villages. And they are, it's called the Conservative Liberty Alliance. That was their handout. I found it to be very informative, you know, overall. But that's their recommendation. That's where that came from.
See, I'd like to say, I looked that over too, and I don't agree with all the decisions that they made on there. And Larry gave a lot of information that influenced that decision on my part. Yeah. And I'd like to have us wind up on a positive note. The positive note is, as far as these amendments go, I think I recognize that I've got to do some more homework and see some of these. I don't want to be part of cutting our. And that's just what you're talking about on these tax abatements. It's going to come down to the local government. And your local government's going to have to approve all of those. I'd like to see an impact. If every one of those got approved, what would the impact be to our local government? If their local went through, then our government would, we could go on the crystal ball. So that's you need to really look at those things and find out, according to your own heartfelt decision, whether you want to support that or vote against it. So I'm going to end on a positive note. I want everybody to know that this Tea Party is part of a group called the Tea Party Network. And we met a couple months ago over in Gainesville, and Larry was there, and I want the positive note I want you to end on is Larry has legislation last year, American Laws for American Courts. It didn't make it through the Senate. You're going to bear with me a little bit, Larry. But he's reenacting that in his coming session. Do I understand that correctly?
Yes, sir. I'm bringing it back.
Okay. Now, does everybody know what that means? American Laws for American Courts. Think about it. So we have a terrific representative here. I appreciate the time that he spent here, but on top of
With that, I'll say good night, and I'll be around for any individual questions. Appreciate the opportunity.
All right, we got a raffle here.